Dr. Zakira Dokrat is at the National Institute for the Humanities and Social Sciences and is busy with a postdoctoral research, or is a postdoctoral research fellow in forensic linguistics. Dr. Dokrat, welcome and thanks very much for joining us on 702 Drive. You have raised the question of the language used in the court, and you seem to be saying in this article that it is really exemplified and highlighted by what's going on in this particular court case. Good afternoon to you. Please tell us why you think these matters need to be raised with this particular court case in mind.
Good afternoon, John, and good afternoon to the listeners, and thank you for having me on the show. Well, I think it raises a number of issues, and it's cast a spotlight on linguistic training of our, not only of our judges, but also our legal practitioners, the linguistic sensitivity that we have towards fellow colleagues in courtroom discourse, the language policy for courts, which is English only, as well as the competency, John, of our interpreters and the important role that they play within courtroom discourse.
So give us some examples from this particular court case. As you were watching it, what caught your eye and ear, and indeed that of your colleague, Professor Russell Kashula at the University of the Western Cape?
Yes, Professor Kashula and I, when we wrote this article, we specifically wanted to highlight the linguistic challenges that African language-speaking legal practitioners face in courtroom discourse. I mean, we focus mainly our attention on interpretation and witnesses and accused persons and their linguistic rights. But this case specifically focuses on, or highlights, I should say, the lack of ability. And I don't want to actually use that because it places Advocate Tefu at a disadvantage, which is not his fault. John, it actually shows us that when Advocate Tefu ran out of words, so to speak, in trying to ask his question in cross-examination, it showed that he would be much better placed to have put his question across to the witness in his mother tongue. And you actually see Advocate Tefu's frustration. And it also raises the issue of linguistic sensitivity, where sometimes we make value judgments about people based on how they speak, how they articulate themselves, and the level of language that they use. And particularly in this case, where the judge actually giggled. I'm not sure if people picked up on that.
Yeah, I didn't see that.
And sometimes we have sometimes inappropriate reactions. But I mean, not in courtroom discourse, John, in a serious setting like this.
So
it also...
Yes, do carry on.
It also speaks to, our judicial officers and their linguistic sensitivity and recognizing the fact that not everybody has a good understanding of English, and that doesn't reflect on their intelligence at all, John.
I recall an exchange between Advocate Tefu and the only witness we've heard so far, Sergeant Thabo Mosia, in which Advocate Tefu on a number of occasions said to him, if you seem to be struggling with English, and I, if I'm not mistaken, Sergeant Mosia eventually began to speak Setswana, and an interpreter was then feeding it back into the court. So it seemed to have affected a number of people. If what you're saying is a significant limitation, it extended beyond more than just one participant.
Yes, it actually shone the spotlight on the police through Sergeant Mosia, because again, it wasn't Sergeant Mosia's fault that he couldn't answer the questions in English or understand them perhaps, and he needed a Sesotho interpreter, which the judge pointed out to him he was well within his rights to ask for. So at that point too, we have to look at our police officers and see they have to do everything in English, from writing of statements to conducting the investigation and so forth. And they undergo no linguistic training whatsoever. And that points back to the issue with our policies and our legislation and how monolingual these policies and pieces of legislation are. So it's not the fault of the police officer, it's not the fault of the legal practitioner, or in this case, the judicial officer. Yes, sorry, John, I'm interrupting you.
No, do carry on.
And, even with the interpreters, because we see in this case the isiZulu and Sesotho interpreters being brought into court, and it's, again, not the fault of the interpreters either, because they don't have sufficient training in South Africa. And they are not only trying to fill a linguistic gap, they are trying to fill a cultural gap as well, and trying to find equivalence between two languages. And we see many inaccuracies arising in this case with the isiZulu and the Sesotho interpreters.
So solutions, they're not going to be quick and they're probably not going to be comprehensive, but where would you start?
Look, definitely not. I don't think we can all wake up tomorrow and we'll have a perfect legal system that's multilingual and where courtroom discourse happens in languages other than English. But look, John, we need to start somewhere. And the primary issue is this monolingual language of record policy that was taken in 2017. We're hoping that with Justice Sondo coming in as the new Chief Justice, and Judge President Maya and the SCA hopefully coming to the Constitutional Court very soon, we're going to see a change in policy and how things are done. I mean, we've urged the judiciary to relook at it, to say how can we take a more inclusive multilingual approach to using language in our courtrooms. And also, once again, I urge the police ministry to contact us as forensic linguists and say, how can you help our police officers? How can we train our police officers? And how can we train our current judges who are not multilingual or who are monolingual or bilingual and say, how can you be more sensitive to the use of language within courtroom discourse from a legal practitioner's perspective?
News.
Experts.
Analysis.
Where things stand.
What you need to know. Drive home with John Perlman
On 702.